Hey, good morning, everybody. Welcome back to Law and Legitimacy. We had a little bit of a break last week. Those of you who were wondering about us, we were fine. Mike, how Mike was picking his first jury in
Yeah, it
federal
was.
court. I want to hear more about that. How are things down in North Carolina?
They're great. We finally made it through all the rain. Sunshine is out this week. It's gonna get back to, characteristic, late spring, early summer temperatures here in North Carolina. How are you, Norm?
A little on the chilly side up here in New England, and bracing for a series of professional challenges. The appellate courts are still considering whether to enforce my suspension incident to the Alex Jones case, and so, being the dire pessimist that I am, I'm bracing myself for that, and asking myself, what am I going to be doing for 6 months, and what am I going to be doing for income? So anybody that's got a side hustle out there for a lawyer with a mouth and an attitude, let me know. I know one thing I won't be doing. I won't be appearing at as I was invited to do at the Michigan Association of Criminal Defense Lawyers to give the keynote address on the challenges of a lifetime spent defending folks of serious crimes. I was disinvited. I was canceled. The board called about 6 weeks ago, maybe 8 weeks ago, offered first class airfare, an honorarium, a hotel, a couple days in Grand Rapids, and an opportunity to address the Michigan Association of Criminal Defense Lawyers, which was quite frankly a thrill for me. I was born in Detroit, and the idea of returning to the state of my origins was somewhat intriguing. But last week I got a call, and the invitation has been rescinded. The Michigan Association of Criminal Defense Lawyers board voted a split vote to cancel me. And the basis of the cancellation was in a video of an old comedic performance that I did in East Haven, Connecticut, some 3 or 4 years ago, where I tried to play around with George Carlin's 7 prohibited words, but I did prohibited identities and saved the N word as my last word of the performance. And what a last word it was! I had to be escorted from the room. There was nearly violence there, and it's not among my best performances. I'll be honest with you. I wish it weren't online, but I was unhappy to be canceled by it, and somewhat surprised that a group of criminal defense lawyers would cancel someone on the basis of controversial speech. We are in the business, we in this trade, of standing next to people amid life's most dark and sometimes defining controversies. I wrote a piece after the cancellation, or not after the cancellation, after the controversy in East Haven, called "Who Owns the Language?" And I tried to explain. It was on my blog page, which, yeah, I think is still online. And the blog post basically said, Nobody owns the language. When a black comic drops the N-word for comedic effects, no one really has much to say about it. When a white comic does it to note the irony, all hell broke loose. And there was an effort on behalf of some in the NAACP to try to attack my law license on the grounds that I had engaged in discriminatory speech. Our position was we hadn't. Bring it on. We were prepared to litigate the issue, and they disappeared. So, I send my regrets to those of you in Michigan who were looking forward to hearing what I had to say. There were things I wanted to tell folks. I wanted to tell folks that this is a vocation, a spiritual vocation, that we stand next to folks in their worst moments, that greater love hath no man than this, that he lay down his life for his friend. And that in a spiritual sense, a criminal defense lawyer is called to do that time and time again. We don't defend the conduct that brings our client to criminal court. Often that conduct is shocking and leaves a mark even on our soul. A man who's indisputably guilty of violating his own child is a person who's going to yield a certain sense of scorn in the breast of everyone. But he's nonetheless a man, and no one is the sum of their worst moments. That is one of my convictions as a criminal defense lawyer, and everyone is entitled to a defense. And so I've spent 30 or so years standing next to people accused of horrible crimes. And those crimes have sometimes left their marks on me. I can tell you that I'm a more somber and sometimes despondent person than I used to be. The weight of it all stuns me. And as I've grown older and people ask me to repeat the stories of my life, I sometimes repeat them with a sense of shock. Thinking, I did that? I was with that guy? holy cow, boy, oh boy, what was I thinking? And what I was thinking was that the state is an artifice, and that um, we're all better off when a person has a vigorous defense, and that defense comes in the form of a criminal defense lawyer testing the metes and bounds of the law, pushing the prosecution and the judge to make sure that the right outcome is received or obtained in the right way, that is according to the rule of law. And I get criticized from time to time on this show for having what I think I'll refer to as a candy ass view of the law. Too much respect for the court, too much respect for judges, too much respect for the judiciary. Guilty, I say. I still say a courtroom is as close as we get to a cathedral in public spaces these days. And in that cathedral of justice, the participants are sworn to play their roles. The prosecutor is a minister of justice, striking hard but fair blows on the name of the people. A criminal defense lawyer has no duty to do justice. A criminal defense lawyer his duty is one of zealous advocacy to his client, bounded only by the duty of candor toward the tribunal and other cardinal rules of the professional conduct. It comes at a heavy burden. Nietzsche once said, "Beware lest you stare into the abyss, that the abyss stare back into you."
Mm.
And those of you who have practiced for a certain number of years know what it is to struggle with the darkness of human conduct. I think there's a reason that people flock to reality TV shows about crime, or that people are scandalized by horrific crimes, and that is, we all know we're capable of them. But for the grace of God, I often say, there go I. And so Michigan, that's that's the abbreviated version of what I would have said. What I also would have said was, be careful to take care to honor the work-life balance, and that no case is really worth tearing yourself away from your home. I've had a busy 5 years, and I've been bruised by my participation in a series of high conflict cases that took me around the country and away from homes for weeks and sometimes months at a time. I'm not sure I'd do it all again if I had it to do over, but I did it, and now I live with the echo of those consequences. A changed and somewhat chastened man. It used to be that I loved to howl at the wind just because I liked the sound of the wind in my ears and the voice howling back. Now I'm a little more cautious, a little more subdued, a little more careful in what I choose to invest my time in. So those of you in Michigan who wanted to hear me, yeah, I was given 90 minutes to speak. I think I took about 8 there, so that's 1/10 of what you would have heard. And you would have heard a series of stories about interesting cases, interesting controversies, times I was compelled to plead the fifth on the witness stand as a result of a client's conduct, cases in which I was skirted the edge of contempt, improbable wins and victory and losses that mark me still. The fact of the matter is that criminal defense is like few other vocations. You stand at the vortex, in the middle of all that can go wrong in human conduct, and you ask yourself over and over, why, why? What can be done? What should be done? The mob may sometimes call for your client's scalp, but you stand as a civilizing influence, saying, but wait, and you hold up a mirror of civility and say to the society at large, let's not become what we fear. Let's strive for something better. And although the system and we as individuals often fail, like Sisyphus, we are obliged to try again and again and again, knowing full well the weight of the rock that bears down upon us. So thank you, Michigan, for canceling me. You hurt both my feelings. There's still time to reconsider, although I suspect that won't happen.
Critical thought over on Rumble says, I agree with you, Norm, and people who do not understand our Constitution history or the reason they walk around with such freedom. The Sixth Amendment is just as important as the rest.
Well, and the Sixth Amendment right to a defense and right to counsel is pivotal, as we all know. So, Mike, enough about me. You picked your first jury in federal court last week. Tell me, what
I
was that
did.
like?
Rather unexpected. I got a call from well, I didn't actually made a call. I got an email, and this has been maybe 10 days ago now, which is how fast all of this has gone. through a listserv, the First Amendment Lawyers Association, a colleague of ours, Norm, that we have in common, made a recommendation to an attorney and mentor of his own that needed local counsel here in North Carolina for a quick trial in the Middle District of North Carolina on a narrow issue as handed down from the Fourth Circuit. And that narrow issue being whether a contract and its arbitration provision was legally binding and enforceable for purposes of moving the overall case forward. So Thursday, Friday, this past week, we had a full trial, sat a jury, selected a jury, sat the jury, presented evidence, examined witnesses, did everything that a normal lawyer does. And within 42 minutes of deliberation, we got a verdict on Friday in our favor. So quick, fast, and in a hurry. But it was quite the experience. I think score one for Norm in terms of our institutions holding. I know that you catch a lot of flack on this stream, particularly when the subject matter is one Trump. However, I will say that the judge and the judge's staff and the jurors, not just because they gave us the outcome we wanted, but everybody there took their obligations to one another as serious as one can. So
I never walk into a federal courtroom without being somewhat in awe
I
of.
love federal court. I think I've said that before. State court and federal court have very, very distinct experiences that they offer, but federal court to me, that's home.
So tell me, was this a group voir dire? The manner in which were you permitted to ask questions of jurors, or did the judge do all the questioning?
So we were permitted to submit questions before voir dire, but the judge conducted voir dire, and it was a mix. It was a group voir dire at first, and then as preemptory strikes were exercised and new jurors were put up for voir dire, it was just a sort of a one-on-one kind of thing between them and the judge, but it was all in open court.
How long did it take to pick the jury?
I would say 30 to 45 minutes. I mean,
I chuckle because last week we finished our jury selection in the state case here in Connecticut, State versus Leon Guerrera. It's a murder self-defense case. Evidence will begin right after Memorial Day. It took us 8 days to pick that jury, but that's the difference between individual sequestered voir dire, where lawyers have the right to question each individual juror one at a time out of the presence of the others, and it's conducted by lawyers. In Connecticut, it's a hybrid right. The state constitution guarantees people, anybody in a trial, the right to question jurors, and then a statute guarantees you the right to do it outside the presence of others. And so it's a unique system in Connecticut that makes jury selection slow. But I kind of, I mean, it's tiring, but I kind of like it because you really do get to know the juror you're questioning, and you get to know a lot about them. And one of the things that really amazed me, I don't know if you were able to see this in the North Carolina experience, was just how little attention people pay to the news. We're sort of, I don't want to call us news junkies here, but we pay attention enough to have a few things to talk about every morning. Most people don't pay any attention, not just to the likes of us, but to the likes of the news, and their lives don't seem any worse for it.
Opposing counsel did try to proffer the question of how the jurors get their news, and the judge was unwilling to go there. I think for good reason. I mean, this is a I wouldn't call it a garden variety, but in terms of how the law is applied, offer, acceptance, consideration, mutuality of assent, it was one of those, just standard contract enforceability actions. Now, I'll say the interesting component of it, Norm, the broader context, this issue started back in 2020, early 2020. And I guess one of the personal biases I have not shared on this stream is my overarching distaste for class action plaintiffs' counsel in general. And for any of those of you that may be watching, maybe don't take that personally. Maybe you should. I don't know. But here's the background is simply this. The defendant, my client in the case, had an arbitration provision. The plaintiff in the case sought to argue that arbitration provision did not apply, and one must ask why they wanted to make that argument. And it was because the plaintiff's counsel that they had was trying to certify that plaintiff along with hundreds of others in a putative class action lawsuit so that they could sue my client for tens of millions of dollars for a potential payout at the end of the day. So it was in their vested interest to get this out of an arbitration, a one-on-one arbitration, and they didn't. So the text message that I got on Friday from the referring counsel, sharing with the counsel, counsel in this one was named Luke LaRoe, Mr. Luke LaRoe out of Florida. I love that guy. But he estimated that we saved the client at least $12 million.
Wow, that's amazing. What good work you did. Dawn McNeil asks, what goes on in the back rooms behind the sanctuary in those cathedrals? In federal court, very little does, Dawn. In state courts, there's a lot of off the record colloquy between judges and counsel. In federal court, there's very, very little. It is not uncommon to be summoned to court and have all of the public's work done on the record. There may be pleadings filed. Those are documented on the record. So it's not a cynic's courthouse or a cynic's courtroom, as near as I can tell, but you are entitled to your cynicism. Hey, the International Criminal Court announced this morning arrest warrants. Benjamin Netanyahu and Yaha, I'm not sure I'm pronouncing it, Yahya Sinwar, head of Hamas, also charged as Yoav Galant, a senior military official, and two top Hamas leaders. It's an interesting decision by the ICC. Neither Israel nor Hamas, I suspect, are members of the ICC. And so the court is one of limited jurisdiction. It can't send arresting agents into Palestine or into Israel to perform these arrests. But should these individuals appear in an international forum, they can be seized by one of the member nations and brought to trial for war crimes. If the just war doctrine means anything, the prosecutions are probably worth bringing in the name of humanity. Sinwar and his cohorts obviously engaged in crimes against humanity on October 7th, 2023, when they raided Israel, killing women and children, kidnapping others, and engaging in acts of butchery and savagery on behalf of their political objectives. Whether Netanyahu and company has pressed the pursuit of of Hamas too far in the months that have followed, resulting in some 34,000 additional deaths, is an open question, and it's a question I'm willing to consider. My sympathies lie with Israel, but there is no denying the fact that this conflict has gone on forever and has decimated Hamas and the Gaza Strip, causing tens of thousands of deaths. Friends of mine who study international law, military officers in particular, talk about proportionate responses. And while a nation has a right to defend itself, it doesn't have a right to extinguish all who support those opposed to it. So I have my doubts about the efficacy of the International Criminal Court. I don't have my doubts about the just war doctrine, and it'll be fascinating to see how this case plays out if Sinwar or Netanyahu are ever actually brought before those courts. No more news from a troubled region.
Yeah, and so it's more news, but I only bring this up. I didn't intend for us to talk about it, but the ICC issuing arrest warrants. I just think it's interesting that Israel and Hamas leaders would be on equal footing from the perspective of the ICC. Hamas as distinct from Palestine and Hamas as distinct from a sovereign government, right? That they would be on equal footing with respect to how some sort of criminal court process should work. I found that just on the surface to be interesting.
Yeah, I do too. Hamas. I'm reminded of, oh gosh, I think it was Saint Augustine who reported once when Alexander the Great brought before him a pirate off the Mediterranean and basically said, what do you think you're doing here on the high seas with your ships commandeering people? And the pirate says, we have but a ship, you have but a nation. The conduct is the same. And so, a sovereign state is recognized under international law as having rights and responsibilities. A movement of people that has not been recognized as a sovereign state is different, but the violence that both enact remain the same. I can't help but think that a two-state solution is inevitable in Palestine, but I'm no study or student of international affairs. I do note your your comment, Mike, and I think it's significant.
Yeah, well, and I bring this up because Iran was standing as is standing in opposition to Israel's interest in the region, right? And Iran had recently launched missiles, and I think the consensus was that the missiles that they launched was not necessarily aiming at a single target, but was designed nonetheless to smoke out the Iron Dome.
Mhm.
And this news is interesting if it's organic, right? Organic in the sense that, hey, maybe the helicopter shouldn't have been flying, in foggy conditions as it was, or whether it's something a little more sinister. And I say a little more sinister because we know that Israel is, chief among the intelligence operations globally, right?
Mhm.
And I don't put it past, Israel or the United States to be able to effectuate something like this, any day of the week. I just think it's interesting in the context of the ICC announcing arrest warrants and the UN, as Barbara also said. I put it on the screen a second ago, but Barbara saying that the UN has reduced the casualty numbers by half there, which is also interesting. A lot is going on in terms of the informational warfare. That is the information as a the information landscape is a battleground, a key battleground in this fight, which I think is really what makes it more of a world war than not. Right? Is that um, sovereign countries around the world are making decisions based on what they're reading. And
I hear you. I
are
just
they
want to
seeing
be
the same?
careful suggesting that somehow Israel or the United States was
Oh,
beyond
100%,
behind
100%. I like
down
I said, I
to
think I don't
fight
think you have
this
to even
helicopter.
I
Yeah.
just think it's coincidental timing nonetheless, right?
Yeah, I hear you. Well, it's certainly troubling timing, and conspiracy theorists will have a field day with that, as they do with everything, because don't let data get in the way of a good narrative. If your rage wants to take a walk, you can always find a theory to
Look at
support.
Janet is quick. Weather reports for the region, the helicopter went are scrubbed from the internet. All right, we'll move on.
Are they really?
We'll move on.
Well, closing arguments are expected this week in the hush money trial of Donald Trump. And, I think they could take place as early as tomorrow. So I thought it might be interesting to talk about the mechanics of a closing argument, what goes into a charge conference, that is what law gets read to a jury, and the judge's role in instructing jurors on the law. Clearly, and I'm surprised. I don't watch a lot of television news. My wife and I are trying to build some back into our diet. And so we watch Michael Smerconish each week because he seems relatively sane by contrast to what most of what's going online. But I was struck this weekend by the difficulty that Smerconish's guests, analysts had in defining what's at issue in the Trump trial. I'm not following it as closely as people who are paid to follow it, so maybe I'm wrong. But I think the matter is relatively simple. There were public reports or requirements of public documents to be reported on expenditures, and expenditures that were intended for hush money were passed off as legal fees. And that's either a fraudulent entry on a record or not. And whether that effort was in support of a federal election could compound or make more seriously that fraudulent entry if it was a fraudulent entry. That's the case. And it's no more complicated than that, or so it seems to me. Yet analysts continue to struggle with it, and they point out what the case is not. It's not about whether Trump had sex with Stormy. Of course he did, and Mershon permitted some PG-13 sort of testimony about that, and then winced once it got to the R-rated line. Fine. So I think what'll happen this week is the parties will submit to the judge what are called requests to charge. Although the law is in many areas settled with respect to fundamental questions such as the presumption of innocence, the need for proof beyond a reasonable doubt, what inferences a jury may or may not draw should a defendant testify or not. Those are what are called boilerplate legal instructions. But how the particular statute at issue in this case is introduced to the jury is a question of some discretion. And so each side will present to Judge Merchan a written version of the quote unquote substantive law of the case, not the procedural law. And because there's very little of it in New York on this statute, at least very little that I'm aware of, the judge will have considerable discretion in what he tells to the jury about the case. And so expect debate on this probably as early as Wednesday. I've read that testimony could conclude on Tuesday. Tomorrow, I haven't read this morning, Mike, anything about forecasts on whether Trump is going to testify. Are you hearing anything about that?
I haven't seen anything either, Norm.
I'm going to assume that he does not, which is counterintuitive. It's hard for me to imagine him avoiding the stage. However, the case appears to have been pretty well defended by his lawyers. The fact that after 4 weeks, commentators are still puzzling what the case is about tells me that New York has not done a good job drilling down on a theory of the case that will persuade jurors. If the commentators who are, and these are experienced lawyers for the most part, who are paid to observe the case and have many years experience in criminal law, can't tell what's going on, how's a jury? And I know I've heard that there are 2 lawyers on the jury panel. That's that's an interesting decision. I
Well,
always want.
interestingly enough, there was an attorney that we kept on our jury panel last week. So I
And why
think
did you do that?
so I thought because of the I'm gonna stay away from describing who he works for, but the type of work that that lawyer does lended itself to our theory, which is that um, everything need not be perfect in order for enforceability to be established, right?
Mhm, mhm.
And the type of work he did to me lended itself to that. Also, just for the administration of deliberation, it's always helpful to have an attorney in there to keep the other non-attorneys focused on what the elements are that need to be established in order to reach a verdict. And I think it's almost like having a consultant. It's not good or bad, right? You have to kind of weigh out what you think they're going to think personally, right? But I think it's always a good idea. Not always, but it can be a very helpful thing to have an attorney in the jury box.
I've often thought when I have a defense that I believe in, I want an attorney so that he'll understand what I'm saying and enforce it in the jury room. I think a party who doesn't want an attorney on the jury is usually afraid of their case and afraid that the jury might
I
get it
agree with
right.
that. I agree with that.
And so I think both sides in this case wanted counsel on the jury to help deal with the intricacies of the law. So let's assume, so Merchan is going to give a charge on the law that'll likely be controversial. This will be a key source of appellate issues. If the people of New York lose, they cannot take an appeal. That would violate Trump's right against double jeopardy. Once jeopardy attaches, that is, once the jury is sworn, game on for New York. They either win or lose. They don't have a right to an appeal. If Trump loses because he is and is convicted, he may or may not decide to take an appeal on how Judge Merchan charges the jury. So it's an important moment at the trial. The jury charge will probably take 90 minutes or so to read to the jury, and I suspect the jury could have the case as early as Friday. Whether they reach a verdict this week or not, it's hard to tell. I also noticed an interesting blurb with, oh gosh, who's the CNN guy? Gloria Vanderbilt's kid.
Cooper.
Yeah, Anderson Cooper,
It's
apparently.
funny mentioning of Vanderbilt.
Yeah. Anderson Cooper came out after viewing some of the impeachment of Cohen and thought that Cohen got clocked. And apparently there was a moment where Cohen was impeached. He testified that he was speaking to Donald Trump about, or a Trump representative about hush money payments. But it turns out that what he was talking about was some spam and some pranks that he was subject to by a 14-year-old. And when confronted with that, he doubled down and looked like a pretty shaky witness. Whether that will be enough to benefit Trump or not, I don't know. But I'll go out on a limb and I'm going to predict a conviction on most or all of the counts. This is a Manhattan jury, after all. whatever technical defenses Donald has. It's obvious to me that they did finagle the reporting. And whether they finagled the reporting to keep embarrassing news from Trump's family or from the electorate, it hardly matters. It could
Or if they finagled reporting, as you say, just to use your verbiage there, as part of, I think, what I on Wednesday, I believe I was talking about this, and that this is an industry all its own, right? This purchasing stories is an industry all its own, right? So the Daily Mail does it. Any of the UK online publications, they're known and notorious for paying cash in exchange for these sorts of stories, whether they're embarrassing or not, and whether Trump had judged for himself that the ROI of spending the money to purchase a story was better than having to defend, you know, uh, or deploy a crisis management team publicly, whatever. But I think my problem with this, I've kind of honed it on, Norm, is not necessarily what Trump did all its own, right? In isolation, it's knowing that this sort of thing is done repeatedly and has been turned into an industry behind the sort of the Me Too movement, right? Such that there is no gap certified accounting requirements attendant to purchasing stories that may have something to do with a public figure's sex life.
Well, I want to comment on Ahava's comment.
Alleged sex life. Yeah.
Yeah. Norm, the judge overruled almost every objection from the defense and sustained those from the prosecution. The judge wouldn't allow relevant evidence and allowed testimony that had nothing to do with the case. That's why there are appeals. I mean, look, judges have considerable discretion to sculpt what a jury hears, and as evidentiary rulings are evaluated from an abuse of discretion standard. You know, I don't take much stock in the fact that the judge overruled almost every objection from the defense. If they're stupid objections, he's going to overrule them. If he sustained those from the prosecution, they may have been well founded. I didn't get a chance to read the trial transcript. I wasn't there. Sometimes a lawyer objects just to throw off his adversary. Yeah, I had a case years ago, very difficult case against a senior prosecutor in New Haven, and I objected a lot, and he got frustrated with me. So at one point, I said to the judge, "May I have a moment with counsel?" And I went to his desk and I took a pen and I drew a little X on his table. And I said, "That X marks the spot. And I want you to imagine every time I object, putting a quarter there." Okay. I said, "Win or lose or draw on those objections. At the end, there's going to be so much money there. I'll take you to dinner at the restaurant of your choice here in New Haven." And so the objections served a tactical turn. I think this business of handicapping the trial based on press reports is unavoidable in a high profile case. Let's see what the transcripts
I don't.
reflect.
I'll go on a limb. I'll just take the counter, and I know I'll be more popular for it. So maybe I'm doing this for the wrong reasons, but I don't think they get to a conviction. I don't think that I don't think that the jury exonerates him. I don't think it goes that far. If anything, I think that there's likelihood of a hung jury on this case.
Let's find out. Let's find out. Well, listen, folks, we've talked our way through another half an hour of your life today, and we didn't even get to the most.
Yeah, the only thing I wanted to talk about was self checkouts. We could do that tomorrow. But yeah, it looks like California is looking to ban self checkout as an option, and me thinks California might have stumbled onto something of a good idea. But we'll talk about it tomorrow.
That works.
I'm notoriously on the side of getting rid of anything that requires people perform services on behalf of a company without compensation. I'm not a volunteer. I'm shopping there. I'm a customer. If you want me to work for you, you give me a discount or pay me. I don't care which one. But self checkout is not about efficiency. All right. Well, let's just dispel that. Anyway, Norm, what you got?
Well, I got done for today. I got work. I got lawyer work I got to do. Mike, how do people find us? How do they support us? How do they build us a platform that folks can't cancel?
Yeah, we are on YouTube, Rumble, and on X at LawPod Daily. On Rumble, we are Law and Legitimacy. I'm saying this because Janet mentioned that we should have one. We do have a locals channel, so you can support us on locals. That's lawandlegitimacy.locals.com. You can also find us on all the podcast platforms, so as Apple Podcast, Spotify, Google Play, Overcast, wherever you find premium podcasts. We're here every Monday through Friday, 8 a.m. Eastern Time. and we're live. So at LawPod Daily, please make sure you have subscribed to this channel, you've liked the video, and you've considered, and on the greater weight of your consideration, have decided to share it with at least one person.
And Dawn, I love you, but just because I disagree with you doesn't mean I know nothing about the case, its context, history, process. Actually, I know quite a bit about it. We just happen to disagree, dear. Ad hominem attacks are beneath you. Go play some pickleball.
Ad hominem for ad hominem. All right, everybody, thank you. Dawn, nice to see you this morning. Appeals are a great lawyer employment mechanism. I agree with that. AMF, yo. AMF.
AMF.
See you tomorrow morning, Norm. See you, everybody. Thank you.